Dear friends and subscribers, Vanakkam. I am Raj Nandakumar, advocate from Villupuram. Today, I am going to explain a very important and recent judgment of our Honorable Supreme Court of India, which directly affects widowed daughters-in-law, family property disputes, and maintenance rights under Hindu law. This judgment answers a very long standing legal doubt and extremely important for women's rights and social justice. The Honorable Supreme Court has clearly held in this case that a widowed daughter in law is entitled to claim maintenance from her father in law's estate. Most importantly, the court clarified that it does not matter whether she become a widow before or after the death of her father-in-law. This judgment was delivered by a bench consisting of Justice Pankaj Mittal and Justice S.V.N. Bhati. Let me briefly explain the background of the case. The dispute arose from the estate of late Mahendra Prasad, Dr. Mahendra Prasad, who passed away in December 2011. He had several sons. One of his sons had already passed away earlier, while another son was alive at the time of Dr. Prasad's death. Dr. Prasad had executed a registered will in the year of 2011, under which his properties were bequeathed to his grandchildren, and one of his daughter-in-law was appointed as an executor. After Dr. Prasad's death, one of daughter-in-law, Gita Sharma, wife of one of his sons, filed a petition seeking maintenance from her father-in-law's estate under the Hindu Adoption and Maintenance Act 1956. At the time when her father-in-law died, her husband was alive. This is the most important crucial thing in this case. This is the decided fact in this case. At the time when her father-in-law died, her husband was alive. So she is not a widow at that time. Later, her husband also passed away, and then she became a widow. The family court rejected her claim, maintenance claim, stating that she was not a widow at the time of her father-in-law's death. However, the Honorable High Court reversed this decision and held that her maintenance petition was legally maintainable. This order was challenged before the Honorable Supreme Court of India. Now we are seeing that decision. The main and central legal question before before the Honorable Supreme Court of India: can a daughter-in-law who becomes a widow after the death of her father-in-law still claim maintenance from his estate? That is the main question. Yes, Supreme Court carefully examined Section 21 of the Hindu Adoption and Maintenance Act 1956. The court noted that the act includes any widow of a son, as a dependent. The Honorable Supreme Court observed that the words used by this legislature are plain and unambiguous. Plain and unambiguous. The Supreme Court further made it very clear that the law does not use the expression widow of a predeceased son. So, the Supreme Court made it very clear in this case, the law does not use the expression widow of a predeceased son. Instead, the legislature very consciously has used the wider expression any widow of a son. So the difference is there. Widow of a predeceased son. It is not a widow of a predeceased son. It is mentioned in law as widow of a son. So any widow of a son. This is the most thing. Therefore, the Honorable Supreme Court held in this case that the timing of a woman becoming a widow is totally irrelevant. The court cannot add restrictions which the legislature itself has not provided. The Supreme Court also warned that denying of maintenance on such technical grounds would violate Article 14 and 21 of the Constitution of India. Such a narrow interpretation would be arbitrary, unfair, and would expose widowed daughters-in-law to financial hardships and affecting their right to live with dignity. Finally, the Supreme Court Supreme Court upheld the High Court's order and held that Geeta Sharma is a dependent under the law and is entitled to seeking maintenance from her deceased father-in-law's estate. The court further concluded the main thing: all heirs who inherited the estate are under an obligation to maintain the dependent. Dependent means here the Geeta Sharma, the widowed daughter. So, accordingly, the appeals were dismissed before this Honorable Supreme Court, and the family court will now decide the quantum of maintenance. The judgment is a landmark ruling in favor of widowed daughters-in-law and reinforces the principle that maintenance laws must be interpreted in a human and constitutional manner. This legal position has now been consciously settled by the Honorable Supreme Court of India in Kanchana Roy versus Geeta Sharma. This is the case law name. Decided on 13 January 2026. That is the very latest judgment, and this is reported as 2026 INSC 54. Thank you, friends. If you feel this would very useful message with legal awareness content, please be share to your friends and circle for their good self. Thank you.